I'll give you all a moment to make your way back to your seats. I was asked to do a different subject than I did last year for Gov101. Last year I did something on conflict of interest, so I'm here to scare you. And this year I have an equally comfortable topic, responding to grand jury reports. I was not here. I apologize for the start of the meeting, but could I see by a show of hands how many people here actually are board members of special districts?
Board members of what?
Special districts, any kind of special district. We got an extra minute. Okay. Chances are, during your term as a board member for whatever district you're in, you're going to have to do this. You're going to have to respond to a grand jury report. And as we're going to go over, the grand jury has certain powers and authority, and you have certain legal responsibilities in regard to their reports. It is not okay. This is probably, some sort of anecdotal story that really isn't true, but it is not okay as a special district to take the report regarding your district, scribble okay on the front of it, and send it back. That's not a response. What is the grand jury? Some people get confused about the grand jury because most people are familiar with grand juries in the criminal context. California is somewhat unique. We have a civil grand jury. It is a government watchdog. That is its primary function. At one point in time, the same grand jury that did the government watchdog function also did criminal indictments. For reasons that I won't go into, and you can ask the district attorney about if you have time, starting in the 1970s, it no longer became possible to do that. Jurors in criminal cases have to be selected from a representative sample of the population, and grand jurors essentially select themselves. They are volunteers. So, civil grand jury is a government investigative body. The state has something called the Little Hoover Commission, which is supposed to investigate state agencies. Grand jury investigates local agencies, and that includes all of you. So the first question, who are these people and why do they think they have, some right to come in and look into what we do? The answer is because the law tells them so. Specifically, they investigate, usually through committees, either citizen complaints or they investigate things because it's come to their attention through the newspaper. Sometimes it's just your turn. They look and see how long has it been since we've investigated certain agencies, and they go out and check them. At the end of the year or sooner, the grand jury will issue reports, and they publish that, and it's a public document. It goes to public officials, it goes to libraries, it goes to the media, it goes to the public. Now it goes on the grand jury's website, and eventually a copy of the reports and responses go to the state archives in Sacramento. Now, as I said, why is it the grand jury gets to stick its finger in the business? It's because one slide too few. Sorry. It's because they are entitled to do that. The conclusion of their service, which is a year, term of the year, is the creation, the drafting of a report. And the report will contain two things in it. It may contain more than two, but it has to contain at least two. Findings and recommendations. And the governing body of the public agency subject of the report has to respond to the findings and the recommendations in the report within 60 to 90 days. For all of you, it's going to be 90 days. None of you are county officers, and it's only county officers that or department heads that may have to respond earlier than that. The powers and duties of the grand jury, again, why do they get to be in your business? Because they're investigating and reporting on various civil matters of blah, blah, special district government. And then just to make sure that you get it, it says including special districts. In addition, they have the ability to examine books, records, and basically any other thing that is used by you, relied on by you, owned by you, and they can look into how you do what you do, how you discharge your function. And again, that's for any taxing agency. Who's here for a special district that doesn't get property taxes? Because if you are, you're in the wrong room here. Public agencies get property taxes, and this is what subjects you to grand jury review. Now, that does not mean, just because they're supposed to investigate and report, that does not mean that they have to criticize. Some people react when the grand jury shows up or they call on the phone and get a letter from them. They react as though someone says there's 60 minutes in your lobby. What did I do? Why are they here? Who are they? Why do they get to do this? Well, you don't have to do that. As I said, there may be any number of reasons why they're looking into your operations, but they don't have to criticize you. They just have to report on you. And if you look at the grand jury's reports over the course of years, which you can do on their website, you will see that a number of their reports are positive. They investigated, they reviewed, and you know what? This agency is doing a darn good job. That happens. So it doesn't necessarily mean by their investigation that they are going to be reporting to you or on you negatively. There seems to be some concern that grand jurors, some of whom are in our audience tonight, are some sort of gadflies with agendas. And they're out to get you. To reassure you on that point, they do have rules that govern their conduct. They have a lot, actually, of rules that govern their conduct. And those rules are the same as the standards that would be before a trial court. They can only take evidence given by witnesses who appear and are sworn and testify under oath. They can only look at things, writings, material objects. Has to be contained in some admissible record or otherwise admissible in a superior court trial. They do have the ability, I'll go over this again, they do have the ability to subpoena persons, records, or things. A subpoena is a legal order which comes to you and says, bring this or be here at this time and place on this day. And you disobey a subpoena at your own peril, because I can tell you, I am the legal advisor for the grand jury, or one of them, what happens if you don't. They call their lawyer, and then we go on down to the court, and we have an order to show cause why you all should not be thrown in jail for disobeying the subpoena issued. There's a further trial that goes on by that, but you cannot disregard those. If you ever see the word subpoena, that's not a joke, that's not a request, that's a must. And that's when, if you see that, you really need to call your lawyer. The grand jury does basically one thing. It does it different ways, different times, does one thing. It reports. I always tell grand juries when I train them, you do two things. You investigate and you report. That's what the grand jury does. They report. They do not have the power to make you do much of anything in regard to how you run your agency, how you run your district. They have the power to make you tell them things. They have the power to make you show them things. But they do not have the power to make you do something. However, obviously these reports are public. They're publicized. Articles are written about them, particularly when they're negative. I've never seen an article in the Tri-Cited Times-Delta about a grand jury report that said the county agency was doing a good job, although I know there are many out there. They look for sort of the salacious headline type details. And obviously that may put political pressure on you. At least some of you are elected to your positions, yes? So your constituents, whether you're elected or appointed, may be asking you, I see in this report, you guys are doing things inappropriately, according to the grand jury. What about that? They have to give you a copy of the final draft of the report, 2 working days prior to its public release. As after it's been approved by the presiding judge. All grand jury reports must be approved by the presiding judge prior to release, and at least in this county, they are also reviewed by legal counsel. So you, as an agency, get this report, and you're told it's going to be released and made public on a certain date. I have been asked multiple times, what on earth is the purpose of that? There are really, presumably there's 2. If it's grossly wrong, obviously you want to call your lawyer, pick up the phone, call the grand jury, and say, there's been a huge misunderstanding here, and perhaps that can be resolved. The other purpose, as far as I'm concerned, is, as we said, they are public and they do garner publicity, and it gives you 2 days, 2 business days, to sort of prepare yourself and how you're going to respond when the press comes calling and saying, what about this? And no comment is usually not acceptable, or we're going to respond in 90 days. I'm not too thrilled about that either. So you have a little bit of time to get your ducks in a row before that report is made public. Now, note this grand jury may, because I want to talk about the difference between may and shall again. The grand jury may request a person to appear. A request is a request, exactly like you making a request. Someone asks, and someone asks you to do something, usually you have the right to say no. In this instance, they can request you to come before them to discuss the report and what's in it prior to it being released. They may very well invite you to appear before them, either as a whole body or before a committee, and give them information, address a complaint, answer questions, etc. And you can say no to that too. However, please remember, a subpoena is not a request. A subpoena is, in effect, an order of the court. It doesn't have a court judge's signature on it anywhere, but disobeying it has serious legal consequences. That's a shall, not a may. So you really have to be careful when you're getting this request and if it's a subpoena, you have to obey it. And if you decline to appear at a request, and they're really interested in you, they're just going to subpoena you anyway. So, you may as well go, frankly. However, again, please remember, every year we have this issue. Subpoena goes out. It is legally served on the agency or on an individual. And there's the grand jury all dressed up and no place to go because the witness does not appear, or appears but does not bring with them the things that were listed in, it's called an affidavit ducis tecum, that were listed with the subpoena that the subpoenaed party was supposed to bring. It can be things, can be records, pictures, and then we have the situation where they call nicely first and say, did you have car trouble? What's going on? Some people just say, I'm not coming. And that's just, don't do that. Do not do that. That's not a good thing to do. If nothing else, that is going to ensure that the grand jury, who may not have been interested in you for any particular reason up to that point, is probably going to be very interested in you and how you run things. Oops. You have to respond in 90 days. There are specific things in your response, and you have to address those. You can go further You can put political rhetoric in there if you want. You can do all sorts of things, but you must respond to their findings and their recommendations. You must respond to them, and there's a particular way that you have to do that for each. We're going to go over that. Remember, there's two things that have to be in the report: findings and recommendations. There are often other things. Sometimes there's a little history of something to do with Tulare County. Sometimes the grand jury will state why they did the investigation. There was a citizen complaint, or it was this agency's turn, or there was a lot of publicity about a particular issue. They don't have to do that, and you don't have to respond to that. You have to respond to their findings and their recommendations. Now, elected county officers or agency heads may be required to respond as individuals within 60 days. None of you, as far as I know, are elected county officers or agency heads, at least in your capacity as serving on special district boards. You have to respond to the findings. Findings are findings of fact. This happened, that didn't happen. Sometimes people will say, I can't respond to that because they don't tell me why they say that. They don't tell me who told them that. It doesn't say in the report, where that information came from, and so I shouldn't have to respond to that. I don't have to respond to that. Well, first of all, the law doesn't allow them to put evidence in their reports. It might seem a little squirrely, but that is what the law is. They are not permitted to put evidence or the names of witnesses, and certainly not the names of complainants, in their reports. But you do have to respond. And these factual findings, as I said, this happened, that didn't happen, are going to be listed. And they're in a nice, helpful section called findings. And they're usually numbered, unless there's just one. They're usually numbered. And you have two acceptable responses, or a combination of the two. Two. How many are responses that you can make? Two. Not 17, not I don't want to, not I shouldn't have to because you didn't put the names of witnesses in here. No. Two. This happened. The agency agrees, the agency disagrees. Now you can disagree in whole or in part. And you can go on and specify, we dispute this factual finding for this reason. And you can also do what lawyers call affirmatively alleged. You can go on and say, and this is actually the true state of the matter. But you have to respond, and you have to respond to each one, even if it doesn't say anything that you think is very important. In your materials, there is an actual response prepared by the assistant county administrative officer on behalf of the county of Tulare regarding a report that was issued last year by the grand jury in regard to the county. So it's something like county missing opportunity to collect funds or collect revenue. And you'll see there are a lot of findings in that report, well over 20 of them. And many of them it's we agree, and some it's we disagree in whole, or we disagree in part, and there's a little explanation that follows that. There's also a template in your book, and you can get this electronically off the board's website when these materials go up. It's broken down. Response. This is in response to the report entitled Name of Report. Finding 1. Agree, disagree. Okay? So you have that available to you. And the grand jury knows you have it available to you now. So they're going to be expecting excellent responses. 2 responses for a combination. You agree or you disagree. And that's a finding. A finding is a finding of fact. Something is true or not true. They also make recommendations. This happened. Therefore, we recommend that. In the report that's in your packet, the grand jury found that there were a number of opportunities for the county to institute certain programs to collect for code violations and other types of land use related matters. And they recommended that certain things be done to remedy that. And you'll see in the section relating to recommendations that some of those were already in place according to the county, and some of those were not going to be put into place, and some of those would be put in place in the future? The answer is different for each recommendation. Each recommendation gets its own response. You can't just have, no, we disagree, that's not acceptable. You can have, remember I said there were 2 potential responses to a finding. There are 4 potential responses to a recommendation. 4. 1, 2, 3, 4. You can say, we've already done that, and briefly summarize what you've done. Often this happens because the grand jurors come out in a committee or whatever, and they look around and they say, do you do this? And you say no, and then you think, well, that would be a good idea if we did that. So you've gone ahead and essentially anticipated what the grand jury report is going to say. Sometimes it's been implemented, the grand jury isn't aware of it. In any event, that's one of the 4 acceptable responses. The second is, it hasn't been implemented, but we intend to do that. We've been planning to do that. And if you're going to say that, there's a catch. You have to say by when. Third response, we don't know if we're going to implement that recommendation or not. We have to analyze it. Often, we have to find out how much it will cost. And you include what you're going to be analyzing. That is, we're going to do a financial and practical operational analysis of the recommendation. And you say the time by which you're going to discuss that and make a decision on it. It can't be more than 6 months from the date of publication of the report. Or you can say, we're not going to implement that. We don't agree with that. We don't think it's warranted. We don't think it's reasonable. And you include an explanation. 1, 2, 3, 4. Seems pretty easy, but a lot of agencies have difficulty with this. Each finding gets 1 of 2 responses, agree, disagree. Each recommendation gets 1 of 4 responses. It's already in place, we're going to put it in place, we're going to study whether we should put it in place, or we disagree and we're not going to do that, and with an explanation of why. Now, remember I said to you earlier, the grand jury can't really do anything to you regarding your operations, etc. That's true. That's absolutely true. But if you don't comply with your statutory obligation to respond to their report, they can't do stuff to you. They can do bad stuff if they want to. Usually, at least in my experience, there's an assumption on the part of the grand jury that this has just been an oversight and phone calls are made or such. But you know, if there's a hostile response or no response, you don't take their phone calls, they do have options, one of which is to sue you. They can bring an action against you for something called a writ of mandate. Remember I said it's a statutory duty? That means it's your legal obligation to perform it. A writ of mandate means to compel, to do. Writ of mandate seeks to compel you to perform a legally obligated duty. Not how to do it, not to tell you which one of those 4 responses to give to their recommendations, but that you have to. Attorney's fees would be included in that action. All of you are going to tell me you're very, very poor. I know. The county's very poor too. And I can assure you, again, as the grand jury's counsel, that if they have to go so far as to sue you to get a response to one of their reports, they are going to be asking for attorney's fees. We do not get what Mr. Cabot and others in private practice get, but our hourly rate probably is still enough to make you all stay. The grand jury has another remedy available to it, which is to seek a 3060 accusation. You can see this is Government Code 3060. Those numbers should fill you with dread. How many people have had conflict of interest in ethics training here? Some of you have. Okay. The numbers 1090 should fill you with dread. Numbers 3060 should also fill you with dread. That is a civil action prosecuted by the district attorney to remove you from office. It has a number of bases for it, but the first one is willful nonfeasance in office. Well, willful doesn't mean you intended to be defiant. Willful just means that you took an act you made a decision not to respond. And that is the equivalent of a criminal prosecution. You get a trial by jury. You know, there's a whole lot of bad things that can happen. You have to incur attorney's fees. It's going to be on the front page of the newspaper. People are going to ask you about it in the supermarket. It is not a good place to be. So, don't do that. Don't not respond. That is not an option for you. No matter how distasteful you may find the grand jury's findings and how disagreeable you may find their recommendations, you have to respond to them. You can disagree with every finding that they have, and you can say, I'm not going to implement any of these recommendations, this is why, and you've met your statutory obligation. Pretending it doesn't exist, maybe it'll go away. In prior years, the grand jury has sometimes reported on agencies' failure to report. I can tell you from my personal belief is we have a number of people on this year's grand jury that have served on prior grand juries. I keep telling them they should get a 12-step program because they keep coming back. They really find it interesting and they're very dedicated to it. And I don't think they have a lot of patience for that anymore. I don't think you can expect to see too many reports on failure to respond. I think you can expect to see more that writ of mandate at best. So please do not ignore these. They're not silly. They're not useless. They're not worthless. They're something that you, when you took your oath to uphold the laws of the state of California, promised to do. And you have to do it. That's all there is to it. The materials in here are intended to assist you. You may or may not find that you need the assistance of an attorney to assist you in preparing a response. Sometimes, as I said, the findings are very straightforward. The responses are easy. Sometimes they might be more complicated. But don't ignore it. Don't demand further information and say you're not going to respond until you get it, or some of the other posturing that's taken place in prior years. Respond. Respond, respond. Have I said this enough times? You have to respond. Okay. I believe I have, well, a few minutes for questions. If any of you have questions, would you hold them up? And my wonderful employees are racing to get them. I see there's a couple in the back. If there are any others, would you hold them up so that Candace can bring them forward? Any others? Going? May a grand jury officer or person stand up in your meeting, say they are taking off their grand jury hat, and he thinks you should quit bitching and let this person get on with his job because the board and the public are happy with the manager's spending habits and timekeeping. This is obviously a hypothetical question. The answer to that question is, there's so many questions that lawyers answer, it depends. This specific information that you've given here in this specific situation, if that were actually to occur, the appropriate response would be to contact the grand jury foreman or foreman pro tem, or in the absence of being able to contact them, the assistant presiding judge of the Superior Court, who this year is Judge Melinda Reed, to report what you think is inappropriate conduct. Understand that grand jurors are not surrendering their First Amendment rights because they're on the grand jury. However, coming with your grand juror badge on and putting it in your pocket and making a comment and sitting back down and putting your badge back on would probably not be regarded well by the grand jury or by the judge. Grand jurors who have not been able to understand that they cannot speak, in essence, as a grand juror on matters of public concern while they're serving as a grand juror have in fact been removed. They have not been found to be impartial anymore and have been removed. It doesn't happen a lot. It hasn't happened recently, if I can recall. But if you have a problem with how the grand juror is conducting themselves, actually in any circumstance, that's your appropriate remedy, is to talk to the presiding judge more appropriately to start with at least, the foreman and the foreman pro tem of the grand jury and discuss your complaint regarding conduct. Grand jurors, as a general rule, I'll have to look to my experts over here, but you still travel in pairs, is that correct? Yes. Usually grand jurors that are there on official business will be there in groups of 2 or more, and they will say they're here on official grand jury business, and they will tell you what they want and why, or not always why, but what they want. Very rarely that you see a single individual. It happens sometimes. Sometimes people will stop on their way home to pick something up or whatever, but for the most part, they do tend to travel in groups of at least 2. And, they're grand jurors, they're not the Gestapo. They are expected, and they may have lots of rights to investigate you, but they don't have the right to, march in and shut your operation down and call your employees names or something. Not that that would ever happen. But if you feel that the conduct of a juror, or more than one, was inappropriate, that's what you should do. And then appropriate counseling or other administrative action would be taken either by the grand jury itself or by the presiding judge. And that's the only question that you handed me. Does anyone have any other questions? Really? Gosh, I thought we were going to have a couple more questions. Thank you so much.